Hi, good afternoon, everybody. Thank you for tuning in to GNG, Gil and Gurpreet's live segment. Today we have a special guest, and it's an honor to have a lawyer, employment lawyer, expert to come on today's show to help us navigate the law, especially in this pandemic, because so many things are changing. Like every other day or every other week, we have new requirements and new procedures to follow. So Shira, I hope I'm pronouncing it right.
Almost there, sure, yeah.
Thank you for joining us. How about you introduce yourself and what law firm do you work with?
So, hi everyone. My name is Shreya Patel. I'm a lawyer at Tork and Mains. It's a full service firm, but I specialize in employment and labor. And I'm hoping to speak about it today about employment and how it affects organizations, businesses, and employees as well. So, thank you, Gurpreet and Gil. I'm excited to be here.
So let's start with the current new requirements. Before we went live, you were telling us about the new, I think, changes that are happening in Toronto and Peel starting this Friday with any workplaces. So do you want to tell us about this?
Sure. So yesterday, the Chief Medical Officer of Toronto Public Health and Peel Public Health announced that all businesses or workplaces, if they have more than five or more employees test positive for COVID in the last 14 days, those workplaces have to shut down for 10 calendar days. There will be certain businesses or workplaces that will be exempt from this requirement, and we will know exactly which businesses fall under this exemption list, I believe today or at least before Friday, because this order, which will be in effect in Peel and Toronto region, will be effective starting this week, Friday. So by then we'll know, which businesses will be exempt from closing down for 10 days, even if 5 or more employees in the workplace tested positive. So this is huge news. And, employers and businesses will have to rapidly adapt to this requirement. And if their workplace is shut down for those 10 days, and, if you have a part-time job at 2 other places and the place that shut down as well, you have to self-isolate and you will be restricted from going and working at the other part-time jobs as well.
So what's the legal requirement for, if you have to legally shut down your facility or your that actual location? What will happen? What's the employer's obligation towards the employees, especially if there's no way to set them up from work from home? Like, let's say it's an Amazon warehouse, for example, where a lot of the outbreaks are starting to happen. Is like, Costco had one here in Peel, in Brampton, Amazon. So I think the Costco one had like 17 employees got positive tested for COVID. So what happens in that situation when you now have to shut down? You have all these employees working in that facility, and they can't work from home. What legally does the employer have to do? Do they have to pay them for that 10-day shutdown?
That there is no such law as of right now that is requiring businesses or employers to pay employees during the 10 days when they're shut down. But from what I hear from the medical officers of Peel and Toronto, they are highly recommending employers to pay their employees, because that will act as some sort of incentive for employees to, report, first of all, if they're sick, and then self-isolate for those 10 days and avoid community exposure and spreading of illness if they step out in the community. So there's strong recommendation, and I also hear the government, the Ontario government, may be looking into paid sick leave. I'm sure you guys are both following the news, and that's a huge ask. Mm-hmm. So we may hear something from the Premier given this mandatory order. And that being said, from my understanding, a lot of employers also have paid sick time off if their workers test positive, or if they have to shut down, or there may be some arrangement that they may have in place given the start of the pandemic that, if the business has to close down for health or safety reasons, they may continue their pay. That's at the employer's discretion. But from a legal liability standpoint. For example, if a business has to shut down mandatory because workers tested positive under this new order, the minimum requirement, even if you're not paying everyone for the 10 days, make sure that the employers continue their contribution for their health benefits. When I say health benefits, that's your health, dental, all those contributions. So make sure you continue them. If you
Dental,
discontinue,
life insurance.
exactly. If you discontinue, employers risk an employee taking the position that they breached a material term of their employment, and that may amount to constructive dismissal, or they're terminating them because the employer didn't continue their benefits.
Mm-hmm.
Although, there may be certain positions employers could take to protect themselves because they're mandated to shut down by your public health department. So essentially, the employer has no choice but to follow the guidelines of your public health department.
So what
And
will happen in
depending,
that situation?
sorry, what do you
So
mean?
if the employer chooses not to now continue the benefits, contributing to the benefits package, because like benefits, health, dental, life insurance, and all that stuff, and if they don't continue that because they're being forced to shut down, what will happen then? Like what's like I know
So
you were
the shutdown is separate from the employer being able to continue and contribute to the employee's benefits, because you can do that and the employees don't have to be physically present. For example, if someone goes on maternity leave, their health benefits still continue,
still active, yeah.
right? So same situation, but from a legal perspective, the risk could be that if you, for some reason, an employer decides, what, I'm not going to continue the health and dental benefits for my employee. The employee could then commence a legal action claiming that because the employer discontinued their benefits, that amounts to constructive dismissal.
Mm-hmm.
And in that case, if there's a contract between employee and employer that allowed or that foresaw this situation, and for some reason, if the employee also stopped their contribution to the benefits, and because in order for the benefits to continue, the employer and the employee had to pay, and if the employee stopped and the employer, was no longer able to continue, there will be certain positions an employer could take, or you could rely on, if on the appropriate situation that there was a frustration of contract, although that likely may not be successful, but without knowing, the actual facts, I'm careful about not speculating as to what the consequences could be. But just so everyone's, mindful of these considerations that may arise.
So would you recommend any employer out there to do that? Like terminate?
No, definitely not. Definitely continue everyone's health dental benefits for the 10 days that if you have to shut down. And for some reason, if you have to continue the shutdown of your business or the premises for longer than 10 days, you can put the employees on layoff. And if employees have employment agreements with the employer, you can legally put them on a layoff under the Minimum Employment Standards Act. And you can either put the employees on layoff for 13 weeks or 35 weeks, depending on if you're continuing any benefits or not. Now, if you don't have an employment agreement that lets you legally put an employee on layoff, and if you nonetheless place the employee on layoff, there's definitely a risk that the employee will take the position that the layoff amounts to termination, and the employer is obligated to provide the employee with all of their entitlements upon termination, which includes, severance pay or termination pay, as you may call it. And hence why, having an employment agreement is very, very, very crucial for both an employee perspective and from an employer perspective as well, because that agreement lays out exactly the expectations the employer has from an employee. And the agreement will also specify the entitlements the employee will have throughout their termination and after their termination.
But how effective is the employment agreement now, given that we're in a pandemic and these agreements were highly likely made prior to the pandemic? Because I was reading this case, I don't think these employment agreements are going to be upheld if it ever went to trial in front of the judge, because especially if an agreement was made prior to the pandemic. So how likely is it that those agreements that were made, any employment contracts and agreements that were made prior to the pandemic will be upheld?
Very likely. So I have many clients, we had employment agreements prepared for them, prior to the pandemic. And when we prepared that employment agreement for them, we typically insert a clause which is for temporary layoff. Essentially, in very basic terms, what that clause does is it contemplates layoff, and it allows the employer to legally put the employee on a layoff for any situation. If there was a shortage of work or a plant has to be shut down, even though you don't necessarily reference a pandemic at that time when you were drafting the agreement.
Yeah.
The way you can draft that provision can allow an employer to place the employee legally on a layoff. So if you had a good employment agreement that contemplated a temporary layoff, and now you're in the middle of a pandemic, and unfortunately, if you have to shut down your workplace or place a portion of your employees on layoff, you can rely on that employment agreement. And if it is hopefully rightly drafted using the appropriate terms, it will be upheld in court.
That's a good point.
Sorry, don't mean to interrupt, but even if you didn't have an employment agreement before the pandemic, or if you had one, but that one didn't mention temporary layoff at all, there are certain ways you can introduce a revised employment agreement with your employees and include a new temporary layoff clause, which will let you legally place them on a layoff.
Okay, interesting. I was going to ask a different question, but now that you brought in the revised contract, now two things. How possibly, okay, so if we're going to, if employers want to give revised employment contracts to their employees, now, wouldn't that, from my knowledge, you have to now give them signing bonus to sign that new agreement. Second, don't you risk if they don't sign it, then you have to now, what's your option if they don't sign it?
So correct. On the first point, that for existing employees, if you're now trying to put them, on a new agreement or a revised agreement, legally you have to give them what we call fresh consideration. And an aspect of consideration could look like a signing bonus, but essentially what it is meant to address is if I'm giving up my rights or if I'm agreeing to a new term of employment, I should receive something in exchange.
Mm-hmm.
And that could be a benefit. Like you mentioned, it could be a bonus. It could be any other sort of benefit, increased vacation time or additional, professional development courses that the employer will let you take, or any other sort of benefit that the employee will receive. And what that may look like, it depends on, is the employee just in a clerical position? Is the employee the CEO of a company? Depending on the nature of their position, the consideration or the benefit the employer gives them will depend on the employee's position. So correct, to go back and answer your question, you do have to give them something fresh, a new benefit. But now if the employee, says, no, I don't want the signing bonus, or I'm not going to sign the revised employment agreement. At that point, everything goes back to the status quo that it was before the employer tried introducing the agreement. So nothing changes. You offered them to sign something and the employee refused. Mm-hmm. And that's fine. So the terms that were governing the employee before, they continue to govern.
Okay.
So you just sort of go back to where you were.
This is why
You just had an offer, they didn't accept, doesn't mean their employment ends.
Okay. This is why I always tell my clients that you should always have employment agreements put in place. Second, always have a lawyer bless it. I'm not a lawyer, but yes, I've taken an HR law certificate to help put these agreements together, but you still want like a lawyer to bless it. I always recommend employment lawyers that are like actual employment lawyers, not a generalized lawyers, because some companies, especially the ones I work with, are smaller and medium sized, so they have like a corporate lawyer. And it could benefit and it could not, because in the employment sector, the employment laws are so much. There's so much to know, so much to deal with, and so many different decisions are made throughout the court. So what's your position on that? Like I always recommend my clients work with, especially for employment, have an employment lawyer that you work with and get them to bless even policies. I run them through employment lawyers. That's why HR works hand in hand with employment lawyers.
Definitely.
Because legal requirements, right? So what's your position on that?
I definitely agree. And every time, we have a new client, and like you said, sometimes they have a general counsel or a corporate counsel, and they try and put together a template, which they then ask us to revise. But that just ends up leading to, more sort of disaster, if I may call it, than an employment lawyer sort of giving their opinion on the agreement from the scratch. And especially because, these days there's tons of materials, tons of templates, information available online that employers try and download and then, put their own information in and present that agreement to their employee. But I'm sure you guys know that employment law is one area of law that in normal circumstances changes a lot. But now, since the start of the pandemic, it's been changing even more rapidly because of new legislations or orders being introduced, and our case law, which is developed by courts or judges, that has been evolving rapidly as well. So that, just to go back to your question, very important, and probably the best practice that you review or have an employment lawyer draft your agreement, your policies, because they will be familiar with the most recent legislation, the most recent case law, and they will have the requisite experience to know how or in which format to draft an agreement or a particular clause that suits the needs of that particular client. You may get a template online and it has a termination provision, but does that termination provision address the needs of your company or how you want to address the liability when it comes?
So, some people do it just to save a couple of $100 or whatever, cost, like just to, saving money. But it's really not saving money if you run into a legal issue. And then it ends up costing you so much more money, legal fees, the case, and all that stuff. Now it's gonna, there's gonna be more costs. So you might as well do things correct the first time and save your cost for long-term purposes. We're talking about long-term purposes here.
Okay.
And you mentioned a great point about online. Now, like we all know, there are tons of information available to all of us online. Now, I never recommend any company to ever just go by what online is saying, especially in termination.
Yeah.
Termination is such a big area, and there's a lot of grays. It's not black and white. And I learned when I did the law certificate, there's tons of things I learned that I wasn't aware of either. And a lot of times what companies do when they're terminating employees, we just, typically speaking, we just look at the Employment Standards Act and just go by that. And it's like, when I took the law certificate, in HR, I learned that no, there's case laws, right? Here's what law will say, but here's case laws, and case law determines a whole different way of severance packages. And one of the biggest thing that case laws / common law looks at is the age, the individual's age, the likelihood of them securing the same employment with the same pay. Now, I want to touch on this. How does this look in pandemic? Because in the pandemic, that might take longer than normally would have, let's say, outside of the pandemic.
Right. So before I address that question, I'll give some context in terms of what an individual can expect when they get terminated and what the company's liabilities could be when they terminate an employee. So now again, I'm sorry, going to go back to the importance of having an employment agreement. But if you had an employment agreement and that employment agreement contained a enforceable termination provision, ideally what that would do is when a company or employer terminates an employee, their obligation would be to provide that employee with their minimum entitlements under the statute. In Ontario, it's the Employment Standards Act. That act lays out the minimum requirements an employee is supposed to receive when they are terminated. So if you had an enforceable employment agreement, that's what the liability for an employer will be. Now, the second scenario is you had an employment agreement, but for some reason the termination provision is unenforceable because case law changes so rapidly, or if there was an amendment to the legislation, or you don't have an employment agreement. In that scenario, an employer has to comply with the minimum statutory requirements, and they have to provide those entitlements to an employee that has been terminated. But that entitlements are the basic entitlements an employee is entitled to. Gurpreet, and like you mentioned, that's the basic that they are entitled to receive. What their maximum entitlement is or would be is determined by the common law. And when I say common law, that's essentially case law that has been developed through, decisions over the years by judges. So under the common law, when an employee is terminated, a court will look at the employee's age, like you mentioned, how long it may take an employee to mitigate their income or find comparable position. A court will also look at the position the employee was involved or employed in. For example, if you're a receptionist, it may be easier for you to mitigate your damages or find a new comparable position compared to if you were a CEO of a company. So that may factor in as well. And age is important as well, because if you're 26 compared to if you're 65, there's something, that age factor will also impact your ability to quickly and efficiently replace your job and find a comparable employment. And based on case law, under the ESA, the basic entitlement is 1 week per year of service to a maximum of 8 weeks, and that's termination pay. Someone could be entitled to severance pay if they meet certain criteria. But for now, let's just focus on the termination pay, which for an employer, if you have a good employment agreement, you're looking at a maximum of 8 weeks. But now if you don't have an employment agreement or one that hasn't been updated in a while, your exposure could be much more, and it could be in months. You could be looking at 2 weeks per year of service per month, or it could be 4 weeks per year of service. So that's roughly 1 month per year of service. And that's your sort of maximum liability under the common law. And your question was, how does that impact or affect in the pandemic? Sorry, you're on mute. I don't know if you're saying something else.
Sorry, I forgot I put myself on mute. Yes. So my question was, how would this impact the pandemic? Because during this pandemic, if a company is looking to terminate somebody, because under the common law, so ES is clear, but common law is where it's not so clear because
Exactly.
different factors get into consideration, and one of them is how likelihood is it for them to secure the same position for the same pay. Now, generally speaking, depending on the position, let's say it's a manager or so on, you can estimate 6 months or so, right?
Sure.
But now in the pandemic, that likelihood could increase.
It could, but so the case law is still coming out. From what I know, there is a recent case where a judge said if this employee was terminated prior to the pandemic, their employment, so like you said in the example let's use, it would be 6 months. But now, if it were in the pandemic, and because of the limited opportunities available in certain industries, like for example, retail,
Yes.
right? So the court didn't go out and specifically say it will necessarily increase it and take it from 6 months to 8 months, but they commented or acknowledged the possibility, or acknowledged that employees are finding it difficult to replace their income or find a comparable job. So their notice period or their entitlement could increase. Because from an employer perspective, they will argue, their hands are sort of tied as well. If the government's telling them to shut down, they can't necessarily open up their retail store. They're financially suffering. So how is it that they're expected to provide this employee with extra compensation?
Now, can company minimize that risk by getting, like, I think companies get they get services of companies with that help with career transition. So with that, if you offer the employee that you're terminating, say, hey, we'll give you X amount of money to go hire like a career coach or career transition companies that help you get back on your feet. What does that look like? Like, how can company minimize? And if they do this, would that exposure of under the common law decrease now?
Definitely. So they offer outplacement services or, agencies that can help the terminated employee brush up their resume, their interview skills, and hopefully if the employee is able to find another job and if they're able to completely mitigate their income, then that obviously reduces the exposure the employer had to the employee after their termination. But again, if a company is financially suffering, they may not have the resources to provide or refer this employee to a consultant or, counseling services where they can re-enter the market after brushing up the skills that they need to. But there are certain other ways, depending on the nature of the company, the industry they're in, their employees, their relationship with their employees, how employers can sort of mitigate their risk.
So we only have a couple of minutes left, but before we,
Oh wow, time flew by.
It does, because you've had such amazing, valuable information. The one question I have, because we were talking about case law earlier, and we were talking about how it's continuously evolving, and even before we went on the air, you said it's even the pace of evolution has sped up through the pandemic. So for people who are watching, are there a couple of significant changes that everyone should know about, every HR leader, every HR practitioner should know about that have happened in the last few months?
Sure. So I'll touch on one, which the one is the business closure effective this Friday. So that's an important one. The second one, if your employees who are on an employment agreement, if there was a layoff provision, or even if there wasn't one, there is a legislation that has suspended the layoff provisions until July 3rd of this year. Before it was only until January of this year, but government has extended that. Basically, what that does is it suspends the requirements of the ESA and until July 3rd. And after July 3rd, if you can restart the clock on layoffs. But the layoff had to have taken effect after March 2020. If you place the employee on layoff in January 2020, you cannot rely on this provision.
That makes sense. That makes sense. Shreya, thank you so much for joining us. Like I said to you before, this is certainly far from my area of expertise. So this is really valuable information, really, really helpful for people to understand, to protect themselves, to protect their people. So thank you so much for joining us. Before we go, if people want to get in touch with you, what's the best way for them to get in contact with you?
find my information through my firm's profile. So look up Shreya Patel at Twerk Mains, and you'll have my email and the number that you can contact me at. And thank you for having me. Like I said, time flew by. Hopefully I was able to contribute some useful information for your listeners.
Significantly. Thanks so much. Appreciate it.
Thank you.
We'll always have to bring you back. It's such a big
Definitely.
topic. Thank you so much for coming on. And thank you for everybody that's tuned in and listened. We'll be back next week, same time, with another great topic. Until then, keep safe, and we'll see you guys next week. Bye.